was no, I don't think anyone would dispute, there's no written lease agreement. That relationship continued for a number of years. The Gunbies actually didn't pay regular rent at all, even though there was an agreement for, the agreement was for $1,400, which was somewhat below market in exchange for the Gunbies kind of keeping up the maintenance on the home. But the Gunbies did not regularly pay any sort of rental, to the Badhams.
Not routinely, or?
No, not routinely.
Okay. I mean, I guess, let me clarify. Is it that there were periodic payments, they just weren't consistent? Or is it that every once in a while they just say, here's some money? I'm not quite sure I'm following.
I'll get to that. So what Mr. Badham did do was he kept a running tally, essentially, of what was owed, both on the personal loans, on the interest, on the utility payments, and on the rental. He kept basically a running tab.
Okay.
And periodically would send this to Mr. Gunbie, just to kind of keep him up to date. All that is really kind of beside the point, because when we get to 2018, the parties had discussions about Mr. Gunbie purchasing the property, and the parties did enter into a 2018 agreement, which is a one-page agreement that they didn't have any. Well, I shouldn't say that. I don't know who prepared it. It's a one-page agreement, and it sets forth a purchase price for the property and a schedule of payments. So the agreement was in 2018, I believe it was June of 2018, and it was for a 3-year term. And it was going to be a series of $8,000 monthly payments with a balloon payment of approximately $200,000 due in June of 21. And the total, the listed price of the property in the agreement is $450,000. The principal listed price is $450,000. But then with the interest, if you add up all the payments with the interest rate, it's a total of approximately $501,000 in total payments that had to be made under this agreement. And the agreement does specify that this balloon payment date is the termination date of the agreement.
So the agreement, if the balloon payment is due in June of 21,
That's right.
then the parties expected that the agreement would terminate either because the payment was made and ownership transfers, or because the payment wasn't made, and then there would be a question as to the entitlement of the Gunbies to remain in the house. Is that your thought? Am I understanding that?
I think, yes, I think there's a dispute as to that, like what the parties thought was going to happen after the end of the agreement. I think that's why there's counterclaims.
But that was in 2021.
Yes, that was in 21.
Thank you.
Certainly, I believe it was my client's expectation that the property would be purchased by that point in time. In any event, only 2 of the installment payments were made in the correct amounts. The first 2 $8,000 payments were made, and then after that, Mr. Gunbie paid in varying amounts, and then stopped paying altogether in the middle of 2019. So from June of 2019 throughout all of 2020, there were no payments made. A few additional payments were made in early 21, but the sum total of all the payments made prior to the expiration or the termination date of the agreement was approximately $114,000. So that's what was paid under the term of the agreement. It's not disputed that after the termination date of the agreement, that Mr. Gunbie continued to make payments to Mr. Badham. But at the time, Mr. Gunbie owed Mr. Badham over $600,000.
Just for the house or for other things?
For all of the debt.
Okay, because my understanding is that not at issue in this case, but sort of the background is that Mr. Badham alleges that he had loaned other monies.
That's right.
Personal loans, et cetera, to Mr. Gunbie.
So Mr. Badham's contention would be that he's accepting these payments towards the other debt that is owed to him because the agreement has expired.
Not that that's before me, but are any of those personal loans, Are they similarly documented to this agreement?
I don't believe they are documented.
Okay.
Yes. And we're not seeking them in this case.
No, I understand they're not at issue here. I just was curious.
Yes. Not documented, other than the spreadsheets that were exchanged between the parties. To reflect the running balance. After, again, some payments were made. The evidence will also show attempts by Mr. Badham to get Mr. Gunbie to complete the purchase of the house under new terms. So once the agreement has expired, there are emails and proposed agreements sent between the parties to reflect new terms that the parties could agree on so that Mr. Gunbie could complete the purchase. But the reality is Mr. Gunbie never was able to come up with any of the funds to complete the purchase. I mean, even under his admitted the amounts that they have claimed to have made under the agreement totals only $452,000, which does not get you to the $501,000. So even another factor in the parties' relationship is that in the summer of 22, the parties entered into a business relationship together for a company, a Bahraini company in the Middle East.
Okay.
And there was an employment agreement signed between the Bahraini company and Mr. Badham. This specified a salary to be paid to Mr. Badham.
Is Mr. Gunbie the owner or the principal member of the Bahraini company? Okay.
Mr. Gunbie was the owner of the company. And the company is, I'll spell it for the core, but also pronounce it, Connaught, Connaught.
That sounds like a very British name.
Yeah. And both of the, Mr. Badham and Mr. Gunbie are both British.
I gathered that from the communication about Mr. Gunbie. I was unaware of that about Mr. Badham.
Yes. So do not be alarmed by accents.
I'll not be alarmed, more charmed,
Yeah,
right? Since the
right.
Americans seem to love a good British accent.
Try not to fall under his spell. Yes. So a business relationship was entered into in the summer of 2022. And so what we would contend that the evidence will show is that many of the payments that were sent to Mr. Badham by Mr. Gunbie beginning in late 2022 and throughout 2023 were reimbursement expenses for this Connaught company. So setting all of that aside, I mean, we never get to the purchase price of the house, nor is there ever any agreement on extending the terms of the original agreement. So fast forward a little bit to April 24, 2024. The Badhams' circumstances had changed. They were living in Europe at the time. And they desired to move back to the States so that their son, who was in middle school at the time, could begin high school in the fall of that year. Mm-hmm. So in the spring, they asked the Gunbies to please, vacate the property by the summer so that they could move back. Instead, they were not met with acquiescence. There was no agreement to vacate. There was just continued staying in the property, without really an explanation other than it's unfair. There was no claim that we had the right to be here. There was no claim that we had complied with the terms. Just considering all the circumstances, we don't feel that's appropriate, and maybe you could find another place to stay for the few years while your son is in high school. And they also got an attorney letter. They also got a letter from Mr. Withers in July saying that we understand you've asked our clients to vacate, but we believe we have a right to purchase the property. And, if you file an eviction, we're going to counterclaim against you. So ultimately, they had to retain counsel, and we hired my law firm. We demanded possession. They did not vacate, and so we filed the eviction action in Fulton State last fall. And we had a hearing on the motion to compel payment of rent to court so that they could remain in possession while the case was pending. And they have done that. So they have remained in possession throughout the entirety of the case. So the entirety of the Badham's son's freshman year, the Badhams had to rent a townhome in the same school district. So the son did not get the benefit of living there. So throughout the last school year, they rented a townhome. They're still renting in Sandy Springs, so that, ultimately when they are allowed to reenter the home, that their son can remain in the same school district. So we just plan to call Mr. Badham as a witness. He will explain the background and the circumstances that I just kind of gave an overview of. And briefly, we'll call Ms. Badham to talk about when she asked the Gunbies to move, what occurred. But that's it. And all we're asking the court for is a writ of possession and the Badham's attorney's fees for having to bring suit. I believe the rent has already been addressed by the state court.
Right, and it is being paid.
It has
I
continued.
checked as of today. It's been correct.
Yes. And that will be another issue we need to address with the honor at the end, but we can't get the rent out without an order from your honor now that it's superior court. But we'll address that at the end. But yeah, so the rent is not an issue. At least the rent as far as the mortgage payment. I think the rent is not actually the fair market rent. It's actually just the mortgage payment and the utilities. So we will be ultimately asking for a modified order to reflect fair market value if they do want to appeal this case further.
Okay.
To account for that. But all we're asking for is for the Badhams to be, reunited with the home that's theirs and that they have the right to possess. And again, there are no written documents that would allow the Gunbies to stay. There's no lease and there's no valid purchase agreement. So that's all we're asking for. Thank you.
Okay. Thank you, Mr. Downs. Mr. Withers?
Good morning, Your Honor. Again,
sir.
Knox Withers and Arnold Golden Gregory. And I obviously represent the defendants and counterclaim plaintiffs, Matthew and Kim Gunbie. This is not your standard run-of-the-mill dispossessory case where the tenant has failed to pay amounts required under a lease agreement. This case isn't clean, and I don't think this case is simple. If this case were simple, if this case were clean, I don't think we'd be here. This case, instead, is messy. You've got parties who attempted to document some of their own transactions themselves without the advice of counsel. You've got other transactions they didn't document at all. You've got my clients who failed to adhere to the strict terms of the parties' agreement. And you've got the Badhams who acquiesced to inconsistent performance by my clients. Those are all factors that take this case out of the realm of the ordinary. Now, factually, I think that most of what Mr. Downs related is accurate. But again, this case is nuanced, and not everything can be categorized as black and white. I'm going to try not to repeat everything Mr. Downs said about the background, but yes, Mr. Gunbie and Mr. Badham had been business acquaintances, and that relationship eventually evolved into a friendship. And again, in 2013, the Gunbies were experiencing some financial hardship. That is a fact of which the Badhams were aware due to their friendship. And as Mr. Downs said, at that time, the Badhams were living in Europe. I believe it was Spain. And the house that they owned at 6365 Coalwood Court in Sandy Springs had recently become vacant after some of Mrs. Del Rio Badham's relatives moved out. So they offered to allow the Gunbies to take up residence there, which was an opportunity for which the Gunbies were very grateful. At that time, the parties did not enter into a written lease or a rental contract. But in 2016, Mr. Badham and Mr. Gunbie began discussing the possibility that the Gunbies would purchase the property. And for whatever reason, it took a couple of years for those discussions to materialize into an actual agreement. On May 5th of 2018, Mr. Badham and Mr. Gunbie did enter into a written purchase and sale agreement. As Mr. Downs said, the Gunbies would purchase the property for the principal amount of $450,000. And as he said, they were to make 37 payments of $8,000 each, with a $205,000 balloon payment on June 30th, 2021.
So let me just back up and make sure in terms of y'all's agreement or disagreement on the facts. So it seems like there's not a disagreement that the Gunbies moved into the house in 2013.
No disagreement.
And then, as you said, for whatever reason, nothing was ever finalized or memorialized in terms of the terms of their continuing to remain there until the purchase and sale agreement was negotiated in 2018.
That's correct.
Okay, thank you.
And likewise, there is no dispute that the Gunbies failed to make all of the payments as and when due. Instead, the payments were sporadic. Sometimes they paid less than what was due. Sometimes they paid more or significantly more than what was due on a given date. Some months, as Mr. Downs pointed out, they didn't make payments at all for months. Nevertheless, the amount of money that the Gunbies paid was substantial. And despite the sporadic nature of those payments, the Badhams never sent a default notice. They never sent a notice that they were terminating the purchase and sale agreement. Even after June 30th, 2021, they never advised the Gunbies that the agreement had terminated.
What about, though, and I'm sure I'm going to hear this in terms of the evidence that will be presented, but I think I understand the Badham's position to be that most of those payments that were made periodically after the purchase and sale agreement either were intended for or were unilaterally received and accounted for by Mr. Badham as payments for other things, not the house.
We dispute that.
Okay.
After June 30th, they continue to make payments, and the Badhams continue to accept those payments. And we contend that in total, the Gunbies paid approximately $437,000 towards the purchase price of the property before the commencement of the dispossessory proceeding. Now, Mr. Downs mentioned $452,000, as I'm sure he will draw out on cross-examination of my client. My client did misapply a handful of payments. I think it was maybe 4 or 5 that in deposition, in discovery, my client said these were for the house, and it turned out he was mistaken on that.
Okay.
But those aside, our position is that we've paid $437,000 towards the purchase price of the house pre-litigation. Additionally, the Gunbies made significant improvements to the property. In total, they spent over $276,000 in renovations and repairs, and those improvements resulted in a significant increase in the value of the property. In April of 2024, as Mr. Downs said, the Badhams decided they wanted to move back to the United States. They demanded that the Gunbies move out, and the Gunbies refused because of the significant payments they had made to the Badhams and the valuable improvements they had made to the property with the expectation of completing the purchase. So in August of 2024, the Badhams filed this case. We asserted counterclaims, and Your Honor asked us to identify what are the claims. We have asserted a claim for breach of contract and specific performance, and alternative claims for promissory estoppel and unjust enrichment. And we had initially asserted claims for fraud, negligent misrepresentation, intentional infliction of emotional distress, and punitive damages, which claims we have since withdrawn. But because my client's counterclaim sought equitable relief, the Gunbies moved to transfer the case to this court. And before that transfer and over objection, the state court ordered the Gunbies to pay over $60,000 into the registry, representing both the utilities and the rent that the Badhams claimed were due from November of 2022 through October of 2024. And again, or in addition, the state court ordered the Gunbies to pay $2,580 a month.
In order to maintain possession.
To cover the mortgage payment and to cover utilities. And my client, as the court noted, has done so. I would like to focus on 5 things that I think the evidence in this case is going to show. Number 1, there was never any written lease agreement or rental contract. Not in 2013 when the Gunbies moved in, not in July 2021 after the last scheduled balloon payment was due, and not at any other time. Number 2, and related, the only written contract at all between these parties is the May 5th, 2018 purchase and sale agreement. Again, it was $450,000 at 5% interest, which, as Mr. Downs noted, you add it all up, it's a shade over $501,000. And it provided that if the Badhams wanted to cancel the agreement, they had to provide written notice, and all payments made prior to the written notice of cancellation had to be refunded. And it expressly provided that no rental payments would accrue or be payable. Number 3. The Gunbies made substantial payments towards the purchase price. Again, we concede that those were sporadic, but significantly, the Gunbies made the majority of those payments after June 30th, 2021, when the final balloon payment was due. My clients made those payments with under the good faith belief that they were still entitled to purchase the property. In fact, in September of 2022, Mr. Badham expressly told Mr. Gunbie in writing that, quote, the deal did not end on July 1st, 2021. In total, as I mentioned, they've paid over $437,000 towards the purchase of the property, and over $300,000 of that was after June 30th, 2021. And $65,000 of that was paid after Mr. Badham expressly told Mr. Gunbie that the deal did not end on July 1st, 2021. Number 4, the Gunbies made substantial improvements to the property. When they moved in, certain portions of the house were or the property were in poor repair, and the Gunbies made improvements based on the Badhams' assurances that they should treat the house as their own, and after executing the purchase and sale agreement, that the house was theirs and they could do with it as they wished.
Are we talking about routine maintenance plus potential repair, or are we talking about remodel?
We are talking about, I think the $276,000 was necessary. It was remodeling, what I would consider to be major capital expenditures.
So it sounds messy, right?
Yes.
In the sense, as you pointed out, that it was going to be. I guess my question, I'm trying to, are we talking about, plaster's cracking and needs to be repaired, the roof is leaking and needs to be replaced, or are we talking about the kitchen's outdated and we'd like a new one with better appliances?
Some of both.
Okay,
some of
thank
both. Some of the repairs were absolutely necessary. You'll hear testimony that they put a new roof on the house. There was a retaining wall that collapsed and that they had to, repair. There was electrical issues. There was HVAC issues. There were plumbing issues. Others, admittedly, were discretionary. But one thing is certain. Beyond normal wear and tear and routine maintenance, the Gunbies spent a significant amount on capital improvements and renovations that no mere renter would ever spend on a property that they did not believe in good faith that they were working to purchase. And finally, as I noted, the Badhams never canceled the purchase and sale agreement. Notwithstanding that the payments were admittedly sporadic and inconsistent, the Gunbies, again, have paid $437,000 directly to the Badhams towards the purchase of the property. That amount does not include the $77,000 that the Gunbies have paid into the court's registry. And that $77,000 that's the $77,000 that covers the mortgage. That's, once you add in the utilities, it's like $92,000 or $93,000. So,
But to be clear, the mortgage belongs to the Badhams, and the money that's being paid into the registry, because it's still sitting in my registry, right? It would reimburse the Badhams potentially, but they are currently still being required to make mortgage payments on that property. Is that right?
I would assume so. I mean, Mr. Badham testified in deposition that the balance of the mortgage was between $100,000 and $200,000, I believe. So I am assuming that he has not yet paid that off. And I don't dispute. I don't think I was aware that the monies had not been taken out of the registry and paid to the Badhams. I for some reason, I thought they had been getting that money from the registry.
I think there's a procedure by which you can make application to receive those funds as they're paid in, but it gets a little clunky with the clerk because as it should be, they don't like to pay out money.
Sure.
Unless it's very clear that they're supposed to pay out that money and to whom.
Right.
So yeah, as far as I'm aware, those funds are, the vast majority of them, if not all of them, are still sitting in there.
Okay.
So I do want to correct the record. They have gotten the vast majority.
Oh, okay.
It's only since the case was transferred to Superior Court.
I see.
Money is still.
Okay. That's the money I was talking about. I honestly disregarded the fact that the bulk of it would have been paid in the state court.
But in any event, the Badhams continued to accept all of those payments, not once sent a default notice due to a missed payment, not once issued a notice that the purchase and sale agreement was terminated, not once did they offer to refund any amounts that the Gunbies had paid to them, as you'll see is required under the contract, and not once did they offer any compensation to the Gunbies for the significant improvements that have added significant value to the property. So at the conclusion of the presentation of evidence, we believe that the court will agree that what the Badhams are seeking to do here is simply unjust. And we're going to ask the court to award the Gunbies an equitable remedy. Specifically, we're going to ask the court to find that the Badhams have breached the party's contract. And we're going to ask the court to enter an award compelling the Badhams to complete the sale of the property to my clients. And even if the court finds that the Gunbies breached the party's contract, notwithstanding the lack of any, declaration of default or termination of the agreement, but in light of the continued acceptance of the payments, but even if the court finds that my clients breached the contract, we assert that the Badhams are promissorily estopped from now declaring a breach and a termination, and that justice requires that they be compelled to complete the sale of the property. We do not believe that the court is going to find that the Gunbies were mere tenants at the property and that the Badhams are entitled to resume occupancy. However, if the court does find that the Badhams are entitled to possession, then we will ask the court to find that the Gunbies are entitled to significant compensation. The amount that the Gunbies have paid since May of 2018 far exceeds what they would have paid in rent over the same period of time. And the improvements that were made were substantial. And so if the court finds that the Badhams are entitled to resume occupying the property, then we contend that the court should order them to reimburse the Gunbies for the amounts that the Gunbies paid in excess of a reasonable rental value, as well as the value of the improvements to the property that in that scenario, the Badhams would be allowed to enjoy. So that's what we believe the evidence will show, and that's what we're going to be asking the court at the end of the trial.
Okay.
Thank you.
Thank you. Okay. Mr. Downs, you may call your first witness.
Housekeeping wise, how do you want to handle this?
You mean in terms of timing? Yeah, because it's noon.
Yeah.
So since we just started at 11, I was planning to at least get a little bit started and then take a shorter lunch. So I would say let's keep going until at least 12:30, find a natural stopping point, and then we'll take about a 30-minute break for lunch.
Totally fine.
Okay, does that work for everybody? Excellent.
Yes, ma'am. Good.
Okay.
Take this.
Don't worry, Deputy, I'll swear him in. Thank you, though.
I'd like to call Keith Badham to the stand.
Mr. Badham, if you'll come up, there's a step up there, and it's a rolling chair.
I'm embarrassed myself.
Why? So be cautious. I haven't had people take a tumble. Before you have a seat, will you raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may have a seat if you'll get situated up to the microphone and then state and spell your name for the court reporter.
Okay, my name is Keith Badham. It's Keithbadham.
And I meant to tell you lawyers, you haven't done it so far, but there's a sticky on that microphone that says don't touch it. Bad things happen when you touch that microphone.
This one, okay.
Yes. Yours may say the same thing, but you're free to it. Careful.
I'm not-
There's a ledge behind you and you're on a rolly chair. So
Gosh, I'm going to slide off. I'm
that's what I'm trying to
one
avoid.
centimeter away from doom. Okay.
But you're free to adjust up to the microphone and make sure that you can be heard, particularly by the court reporter.
Okay.
Thank you. Go ahead, Mr.
Make
Downs.
sure you're captured on camera too. It looks like you're in there pretty good.
Mhm.
All right. All right, Mr. Badham, good morning. How are you doing?
Good morning. I'm doing great.
Okay. We're here about 6365 Colwood Court. Can you tell the court your relationship to that property?
I'm the owner of that property together with my wife. Yeah.
Okay. And how long have you owned it?
I think we purchased that property in 2006.
And you don't currently live there, correct?
No.
Did you ever live there?
Yes, we lived there from the day that we bought it, 2006, through to 2010, when my company transferred me to Australia, actually. Yeah.
And since 2010, have you ever been resided back at the property?
No, we haven't.
Okay, gotcha. And how did the defendants in the case, the Gumbies, come to live at Colwood Court?
Well, in 2013, Matthew Gunbie reached out to me when we were away, living in Spain at the time, because we transferred. I moved around a lot. So he reached out to me and said that he was in some financial difficulty, and would it be possible to borrow some money? And so I discussed it with my wife, and we said, sure. I think you described our relationship as sort of business acquaintances, but, it was probably a little bit more than that. I mean, we were very friendly. And so we thought that it was the right and proper thing to do to help them with some money. So we gave them some money. So that was in 2013. And then I don't know when in 2013 that started, but that started the relationship where, because we hadn't seen each other in many years, because we've been traveling and the Gumbies have moved back to England for a spell and what have you. So what happened then is that then I got to know a bit more about their financial difficulties. And Matthew said that he wanted to move back to America because he felt he could have more opportunity, more work opportunity there. But he didn't have credit. I think that, they'd had a house foreclosed and what have you. So he had no money, he had no financial difficulties. So what had happened is that I had the house, Colwood Court, had been used by my sister-in-law and her family for 3 years, because they too had some financial difficulties after the financial crash and needed a place to recover, which they did, and they're very successful and happy now, which is good. And they just moved out, and I was going to sell it because we were not in the country, and I didn't know when my company was going to transfer me back to the US or what have you. It was not definite. And so we put it on the market, but it was absolutely the bottom of the market. It was the end of the financial crash. And we had a couple of offers, but I wasn't in a position to have a fire sale. So I said, nah, I'm not going to do that. At this time, Matthew had moved back to America, and he called me and said, hey, do you still have the house at Colwood Court? do you think it would be possible if we could move in? Because we have nowhere to live, and they have a large family. They have four kids. I mean, I don't think they were at home then, but maybe, I don't know. But we want to keep the family together, and your house would be great if we could move in. Again, I discussed it with my wife, and we said, sure. Initially, I asked him to pay, because he offered to pay money, of course. I said, okay, well, you just cover the mortgage, and I think we'll be okay. Because honestly, the impression he gave was that he was going to get back on his feet, he was going to get a job, and then he would go buy a house and, start his life again, which is what, say, my sister-in-law had done with the house. He said that he could only afford $1,400 a month, which is less than the mortgage payment, right? So, well, we said, okay, because we thought, okay, it's going to be a short time, whatever. We didn't sign a lease. He was a friend, and we were helping a friend in need. And, we're guided by our faith to help people out. And, that's just what it is. It may be, with hindsight, it may be a little bit foolish, but, that's, we're not going to stop doing helping folks out. And in fact, we've helped probably 6 families in Atlanta with the properties that we own who have been in dire straits over the last 20 years. So he, said, okay, I can afford $1,400. I said, fine, do it $1,400. Honestly, I anticipated this would be a year, maybe a bit more. And then he proceeded not to pay for 15 months. So we were not receiving any money. I was paying the electricity bill and the water bill and the gas bill all through this time. And then they, after that, started to pay. And that's really where the whole Colwood Court story started with the Gunbies. Yeah.
Let me interrupt for just a moment and just clarify what you just said. I think I understood you to say that during that 2013 to 2018 period that the Gunbies were paying the utilities, the power and stuff, but you were paying the mortgage, or you were paying all of those things?
I was paying the mortgage. I was paying probably for the first 18 months, I was paying all the utilities in total.
Okay.
But I had asked them to transfer the utilities, absolutely, but they only transferred the gas bill for some reason.
Probably because the utility companies won't accept it without proof of some right.
Well, maybe there's something there. I don't know, but anyway, I continued to do that because our agreement was that the Gunbies would reimburse us that money. I mean, I was not expecting to be less than from this enterprise.
Understood.
Right? So through 2018, that's what happened. That they paid some money, they borrowed more money. I ended up giving Matthew over $100,000 in loans. Like I said, continued to pay the mortgage, which was more than the rent that they were supposed to pay. The utilities and the reimbursements were sporadic and what have you. So that was really the relationship, prior to the purchase.
How did you have any sort of understanding on keeping up the property?
Yeah. In exchange for giving the Gunbies a very low rent, they agreed that they would maintain the property. Now, if anything major came up that required the insurance, because I maintain the insurance on the property, of course, I have no idea whether they ever took out renter's insurance or anything. I have no idea, but I absolutely have always maintained the homeowner's insurance. If anything happened that required insurance, then they would call me and I would contact the insurance company. They did that for the retaining wall, for example. So that was it. Yeah.
And so your testimony is that the Gunbies, for a period of time, did not make any payments. Is that right?
Yeah.
Okay.
For 15 months.
And after they did start making payments, was it regular?
No, it was sporadic again, and in various amounts, and yeah.
Forgive me, Mr. Downs.
Absolutely.
I need to interrupt you and take care of some grand jury matter real quick.
Absolutely.
Just take a second. Nah,
You're totally fine.
no problem.
I should be thanking me.
Sorry. It is 23rd.
That's right.
Judge Dunaway had in front of you. Lunch. It's a gorgeous day. Good time to be outside. The grand jury indictments have to be returned into open court and then given to the clerk for filing. And so that's what you just witnessed.
Ceremony. Yeah.
Right. So when you hear somebody say that they were returned in open court, this is what it means.
Awesome. I don't ever, not in the criminal world. So
And of course, none of that, Madam Court Reporter, needed to be on the record, to be clear. But please, sorry for the interruption. Please go ahead.
No problem. So with the sporadic payments in OTU, how did you keep track of all this?
I kept a spreadsheet. Which turned out to be a very big spreadsheet, and that just went on from 2013 through to 2018. And then I started another spreadsheet from 2018 when we signed the purchase agreement, or we agreed that they would try and purchase the house. Yeah.
Was Mr. Gunbie aware of the spreadsheet?
Yeah.
How so?
Occasionally we would discuss it. I would email it to him. He would have it. He would review it, and yeah.
Okay. Now, at some point, did you and Mr. Gunbie discuss him purchasing Coalwood Court?
Yes, we did. Yeah.
All right. Tell the court about those circumstances.
Yeah. No, he said that they liked the house. They were comfortable in the house, and they have a large family, and I guess it was a good place for them to get together. I mean, they said that they would like to find some way to purchase the property, but they couldn't get a mortgage because Matthew didn't have credit, his wife didn't have credit. So could we come to some arrangement where they could buy the house? Now, that was on the basis, I'll just add, that we were in Europe, and we had stayed in Europe because for various reasons, but one of them was that our son had some health issues which we needed to take care of in Europe because we didn't have health insurance in Spain, in America, and that's a pretty hefty bill.
Yes, I think all of us Americans in the room are quite familiar with that.
Exactly. So it was much better for us to deal with that in Spain. And so we thought, okay, well, if we can get the money for Coalwood and we can have a friend buy it, there's a sort of nice continuity there. And, and regarding all the sort of the missed payments and everything, I mean, that's just what Matthew's like. I mean, he is up and down and up and down, and you have to accept the friends that you have. I mean, you can't just be so rigid. So while, I in particular, not my wife, but I in particular might look a bit foolish through all these proceedings, I'm just trying to help a friend, really. And
so let me jump in, if you don't mind. What time period are we talking about when you started talking about him purchasing the house?
Yeah, probably like 2016. I think we first started to talk about that, and then, and then through 2017, we discussed some purchase prices. They got an appraisal on the house, and I said, well, I'm not interested in that because it's way too low. And so, eventually we agreed to purchase price, which included, in fact, consolidated all the debts and extra payments to effectively compensate us for our goodwill, right?
Can you explain what you mean by you consolidated the debt?
Well, because so in 2018, he still owed, gosh, I don't know, probably about $64,000. Plus, he'd agreed to adjust the rent on the property a little bit, and that's all documented in various emails that you've had in Discovery. And but I wasn't going to sell. I didn't want to sell the house for $400,000. I mean, I didn't need to, So we came to an arrangement. I said, okay, well, let's lump all our stuff together because he's been sporadic in his payments. And I thought, okay, if he has to pay to buy a house, then surely he's going to pay everything, right? This is a one way to force some consistency on Mr. Gunbie. So that's how we arrived at the number in the spreadsheet, which we'll discuss. And then we came to sign the purchase agreement, but he said that he did not want his wife to know about the extra sums. So could we just put $450,000 in the purchase agreement, and whilst the other sums were agreed and on our spreadsheet, which is in evidence, we'll take that away from the agreement, and his wife didn't need to know that.
Okay. So ultimately, you did sign an agreement for the purchase of the property, correct?
Yes, it did.
Okay. Let's share with you a document.
Can I ask, I assume that what you're fixing to ask him to do is identify the purchase and sale agreement and share it digitally. Do you either have a physical paper copy or can you, thank
Just
you.
for you? Yeah.
Right, or can you direct me to where in the record it already exists?
Yes, absolutely.
Thank you, sir.
Is it hard for you to see on the screen?
No, it's easy. I just I'm despite my youth,
You like
I am a
paper?
paper
I
person.
gotcha. You like the paper. It's so hard to look at documents on the screen all the time. All right. So showing you what I've marked for the court as plaintiffs one, and ask if you recognize this document.
Yes, I do.
Okay. And what is this document?
So this was what's called, well, you can see it's titled a heads of agreement, because the idea was, honestly, that we were going to just basically agree the terms of this purchase, and then we were going to get a lawyer to do a proper agreement.
Okay, well, let me interrupt just briefly to make things maybe more efficient for us. There are, in this index that you've handed me, have you provided Mr. Withers with a copy of this index?
He's got the exhibits. Yes.
Okay. Well, I guess that's what I mean, the 12 exhibits. Is there a dispute? I mean, obviously there might be a dispute about relevance, but in terms of admissibility, it seems like most of these documents the parties would agree on, and so you don't have to ask the three magic questions for every single document. What are your thoughts, Mr. Withers?
Well, Your Honor, I do have some, we're going to be looking at some spreadsheets, which I would have, some objection to on the grounds that they're either hearsay or that, they're summaries of documents and that reflect amounts that presumably come from other documents.
Well, let me clarify. I absolutely don't want to jump over your right to object to a particular document. My question is merely, if we were in front of a jury before we got there, I would have made y'all agree that we agree on the admissibility of exhibits 1, 2, 3, 4, and 12. And then that way we only have to ask questions for admissibility and have an argument about certain ones. And that's really what I'm asking right now. I'll give you a chance to make your argument when that one is offered.
That's fine, Your Honor.
The question is, which ones of these can we agree on?
We can agree on one. And as far as the spreadsheet documents, which are 2 and 3, I have no objection to the email, but I may want to interpose an objection as to the attachment to the email.
Okay.
No objection as to 5.
Not gonna use
Okay, Mr. Downs says he's not going to use number 6, so we can leave that.
And yeah, my index says deleted, so.
Oh, okay. No objection to 7, no objection to 8, no objection to 9.
10 I have is deleted as well.
Okay, no objection to 11, no objection to 12.
Okay, and the only one I was a little confused about is you said 2 and 3, but I didn't hear. So I have 2, 3, and 4 as not having an objection or not objection. I think I heard you specifically say 2 and 3, you don't object to the email, but you are going to have an objection to the spreadsheet. So we'll have that conversation when it's offered. What about 4? Does that fall into the same category as 2 and 3?
No objection to number 4.
Okay.
At least as so far as the document is what it purports to be.
Okay. Well, and again, to the extent there's objections as to other matters, I'm just trying to make sure that for right now, to move us along, exhibits 1, 5, 7, 8, 9, 11, and 12, the parties are stipulating that those documents at a proper foundation could be laid for authenticity and general admissibility. And then as to 2, 3, possibly 4, the parties will raise objections as we go. Okay?
Yes, Your Honor.
Okay, so with that, you may go ahead and inquire about the substance of the ones that have already been admitted.
This, so I'll do it in 1 minute, since there's no objection. All right, you were saying, so,
Yes, I recognize that. I think you asked me if I recognized.
okay, okay. All right, and, all right. Under the terms of the agreement, what was the, what payments were the Gunbie supposed to?
Well, the 37 payments at $8,000 a month, and then a balloon payment at the end of the term.
Am I correct that you refer to this as a heads of agreement, which
So actually, I was told that's where we sort of got
that British English versus American English, but am I correct that the idea is this is an agreement to agree and that the cannot agreement is perhaps y'all's effort to reduce that to writing?
This has got nothing to do with Con.
Nothing to do with that. Okay.
Nothing to do with Con at all.
Okay.
So this was, you're right, this is what we sort of agreed. And the idea was that we would give this to a lawyer, and then the lawyer would put these terms in a proper agreement.
I see. Thank you.
And because we're British and what have you, we didn't do that. So,
So, yeah, you never signed any other agreement?
No,
for purchase of
no,
property, right?
no.
So this is what you're left with?
Yeah.
Okay, all right. And the total payments, if you add in the installment payments and the balloon payment, that's approximately $501,000.
Yeah.
And under the agreement, when did it terminate?
It's terminated on the 30th of June, 2021.
And how many of the 8,000 installment payments did Mr. Gunbie make one time?
Of the 37, I'm not going to do the math in my head, but I can tell you of the 37, he failed to make 23.
How many times did he make $8,000 payments to you on or before the due date per month?
I don't recall, honestly, but not very many. And yeah.
At some point, did he stop making payments altogether?
Yes, he stopped making payments halfway through 2019, and he didn't commence making payments until, I believe, January 2021. It might have been December 2020, but around that dimension.
And under the agreement, does it say anything about what happens if the Gunbies fail to make a payment for a certain series of consecutive months?
Yeah, in 2.4, it says that if a buyer fails to make any payment for 6 months, then the buyer is assumed to have cancelled the agreement per above. Yeah, per 2.3. That if the buyer wishes to cancel this agreement at any time and for whatever reason, no payments will be returned, no value given for any repairs or improvements which will belong to the property.
So, in 2020, You say you testified that he did not make any payments in 2020?
He did not, no.
Let me hand you, show another exhibit to you. This is marked as Exhibit 2, which I know Mr. Withers has. He doesn't have an issue with the email, so let's look at the email. This appears to be an email from you to Mr. Gunbie in December of 2020, is that right?
Mm-hmm.
You have to verbalize your.
Okay.
Yeah, you do have to say yes or no.
All right, yes. Yes, it is.
All right. What is the purpose of this email?
Well, I'm telling him here, hey, you haven't made any payments for 20 months. Now, this was sort of par for the course, as you've heard. But now it's getting serious because we are, our property is attached to this, and all the remaining amounts of money that he owed us and what have you are all tied up in these payments. So I'm saying, hey, there's been no payments for 20 months. So the agreement's void, right? And he's due to end in June. So I'm giving him a heads up because, had he fulfilled the position by June, then yeah, I would have sold him the house. But right now, because he hadn't paid for 6 months, in fact, 20 months, then yeah, of course the agreement voided itself.
And are you attaching something to this email as well?
Yeah, I've attached the spreadsheet with all the missed payments on it and the current position and what have you, this one here, yeah.
Right. So, Your Honor, at this point, I'm going to object. And I realize we're in a bench trial here, so it's a little bit different than dealing, as you might, with the jury trial. But, to preserve a record, I do feel the need to object to this on the grounds that this, I believe, is hearsay. It's a summary of documents or documents that contain numbers. And we don't have those documents to know, whether the numbers that are on this spreadsheet are accurate. And so I would object on the grounds of hearsay and on OCGA 24-10-1006, which is the statute that governs
Summary of voluminous documents. Right. So a couple of things. Your objection is going to be overruled. Number one, because Mr. Badham is a party. And so my understanding of the hearsay rules is that this spreadsheet can be understood to be his out-of-court statements. His testimony about those things is acceptable. And while the absence of the supporting documents might go to the credibility of the information that's being provided to the court, it is still evidence that is being offered by Mr. Badham and I think is admissible. So your objection is overruled. Go ahead, sir.
Thank you.
All right. And just, if you could just explain to the court what the format of this spreadsheet.
Okay, well, yeah, I mean, you can see there that we have our start total, which is the start, so the total, so if the first column is the total describes what the outstanding requirement is, the start total. And then you can see the monthly fee payments. Then I was still paying, even under this agreement, I was still paying power and water because they had not transferred those over to their own name. And pest control I was paying for. And then later on, Ercon lease, where they requested that I replace the air conditioning system there. And I took out a lease for that. So that's the start. So the start of this says that when we began this journey for them to purchase the house, the start date at the start sum was 742,000, which was made up of the 450,000 plus interest purchase price in our little heads of agreement. plus the prior loans and goodwill payments and all the outstanding monies that Gunbie owed me.
What is flex?
It's a flexibility payment. It's basically a plug that says, okay, the outstanding amounts of this, that's for, that's for rent, that's for utilities, and then we still have a gap to where we want to be. So because you've been so flexible with us over the last 5 years, then we'll introduce this to get to a number that we both like. And that's what the flex was for.
Is that synonymous with goodwill?
Yeah.
Okay, gotcha. All right, so you sent this in December 2020, correct? I believe that's when we looked at the date. What was his, Mr. Gunby's total running balance as of December 2020?
It was $670,875.42.
So by the end of the agreement that we looked at, Exhibit 1, I can put it back on. Do you recall how much total payments you had received from Mr. Gunby by that time?
I had received $114,461.
As of June 2021?
Yeah.
And did Mr. Gunby make the balloon payment of $205,522?
No, he did not.
Did he, at that point in time in June of 21, pay any of the difference in the installment payments he owed?
No, he did not.
At that point in time, did you consider the agreement to be terminated?
Yes.
And why is that?
Because the agreement said that if he didn't make any payments for 6 months, the agreement was terminated. And he didn't make payments for 20 consecutively. Yeah.
Did that constitute a hardship for you that he did not make those payments over the 20 months?
Definitely. Definitely. Because during that time, we were still having to pay the mortgage. Like I said, I was paying all the expenses of the house, including the utilities.
After the agreement's termination date, did you continue to accept monies from Mr. Gunby?
Yes, I did.
All right. Why is that?
Because he owed me money over and above the property, as you've seen here.
Did you consider that the post-termination payments that he made to you were towards the purchase of this house?
No.
Why is that?
Because the agreement had terminated.
Did he ever tell you that these payments, these post-termination payments, were for the purchase of the house?
No, he did not.
Did you ever discuss with Mr. Gunby that he had not complied with the terms of this agreement?
No, we didn't. We had some discussions about a house. I mean, one thing is important to note that we did at this time. We were working together in the Middle East,
And that's the Connaught agreement.
Right, okay, I'm going to get confusing now. So this is before Connaught because I was actually Matthew was a partner with Ernst & Young in the Middle East, and he introduced me to some work as a consultant with EY in the Middle East.
I see.
So I've been doing that work. So we were in constant contact throughout the sort of the COVID period and what have you, and post that. So so we may have had conversations. Certainly we were talking about Colwood and about his payments and what have you, which led us into, in January of, I think 22, I sent in the spreadsheet and said, hey, we're done. We need to sort something else out.
All right. Well, I'm going to show you what's marked for the court as Exhibit 3. And this is a January 22 email from you to Mr. Gunbie, correct?
Yeah, yes, it is.
And Mr. Withers, you had not objected to the email itself. Do you have the same objection for your record to the spreadsheets attached?
For the record, I have the same objection to the spreadsheet.
Okay, and my ruling is the same. Thank you, Mr. Withers.
Okay.
Mr. Downs, if you don't mind, it's 12:26. Unless you're going to touch on this just briefly, this would be a natural stopping point.
I think this was a brief one.
Okay, so
Yeah.
Exhibit 3 is admitted over objection for the reasons I stated before. Go ahead, Mr. Downs.
All right, Mr. Badham. All right, so this January 22 email, what are you discussing or what are you proposing here?
So discussing him still trying to buy the house, but I'm saying to him, you know, and this was a brief summary of verbal discussions, of course, but, you know, hey, let's make this happen. So if you pay X, because, you know, we were starting to feel having to pay the mortgage and the expenses and not have any money coming. I said, listen, if you pay this money, I'll just pay off the mortgage. And then we can rejig the sales price to reflect current conditions. That's really what the answer was. That's what this is about.
Okay. And so essentially you're asking him to enter into a new agreement?
Yes.
I mean, in fact, you say, get with your attorney and see what documents are required, right?
Mm-hmm. Yes.
Did he ever transfer the $200,000 to you?
No, he did not.
I think that's all I have for that exhibit. If you want.
Okay, I have one question about that exhibit.
Sure.
I think I understand that the spreadsheet from 2 and 3 are essentially the same spreadsheet, but with different dates, right? Because more time has passed. And a moment ago, I thought Mr. Downs asked you a question about, or I think you would testify that you didn't really have any discussions with Mr. Gunbie about payments that he made during that interim, that they were for the house. And that you didn't believe they were for the house?
No.
Okay. But the spreadsheet attached to 3 shows you crediting payments that he's making to you in 2021 toward the agreement. So tell me what that process was about.
The spreadsheet is a running balance of what he owed, right? So I was just I just added to that with the money that he paid.
Okay. Okay.
Yeah.
Okay. Thank you. So it is 12:29. We're going to be in recess until 1 p.m. And I think the courtroom Sergeant, is the courtroom going to be locked?
Yes.
Okay. The courtroom will be locked, so y'all are free to leave your stuff in here, but that means you can't be in here. So,
Yeah, exactly.
because the sergeant needs lunch as well is the issue. So anyway, we are in recess. You may step down, sir.
I have one bit of housekeeping.
Sure.
Is there, do we need to bring some more water in for the?
No, we have water. Normally my assistant has been out recently, but normally she's an excellent host and brings water, and I'll ask somebody in my office to step in and bring you bottles of water and stuff. Okay.
Thank you.
Thank you.
Leave the computer. You're leaving the computer up? Zoom back?
I'm just going to leave my computer.
Okay. Yeah, because I don't want to mess with the sound.
Yeah. No.
So what do you need? We have until 1 o'clock.
Okay.
You can probably just get out and come back. Yeah, you could probably, you need to grab, you can grab a bite? Yeah, I need to grab a drink. Okay. All right, I'm just gonna stay. Okay.
I can stay here, you know.
What's up?
Stay here. Well, I'm still gonna lock the door, so they just party while they want to come back in.
I think I'm going to step out.
Yeah, I'm gonna step out.
Just because I may need to find a pack of crackers or something.
Yeah.
I have a bad habit of never eating in the morning, and I'm like, I don't want to do
Me
that.
too. Did you hear about?
Someone ask for water?
Oh, I would love just to settle one there.
All this stuff right here.
Oh, perfect. Thank you.
Everybody take what they want, and I'll recollect them.
Did you hear about, I was on the way here this morning and they were talking about some indictment of relating to the NBA, and the mafia.
No,
With some kind
what's
of,
happening here?
no, it's in the Eastern District of New York, but apparently, and I was in the middle of a press conference when I stopped at power, but like apparently the mafia is, and